following grounds, Your Honor. That the homicide investigations officers at DCI headquarters are investigating a case of murder where Dr. Victoria Mutiso, PhD, formerly Director of African Institute of Mental and Brain Health, was murdered on the 29th of July 2026 within Upper Hill in Kilimani Sub-County within Nairobi County. After being trailed and fatally shot by unknown gunmen while she was riding on an Uber, registration number KDJ 609D. Your Honor, the incident was reported at Kilimani Police Station via OB number 35/29/07/2026. And initial investigations were carried out by DCI Kilimani. The body of the deceased was taken to Kenyatta National Hospital mortuary for preservation pending post-mortem examination to ascertain the cause of death. Your Honor, the applicant took over the investigations from DCI Kilimani on the 29th of July this year and initiated fresh investigations into the matter. And a multi-agency team took over the investigations where the team documented the scene of the incident and recovered 2 spent cartridges and 1 bullet head, which have since been forwarded to the National Forensic Lab. The team has also recovered several CCTV footages, which needs to be forensically analyzed, and the process is ongoing. Post-mortem on the body of the deceased to ascertain the cause of death is yet to be undertaken. Preliminary investigations have pointed out that there was a land dispute culminating to civil suit, which was filed by the first respondent at Machakos Law Courts, file number MCELC E111 of 2025 against the deceased's family property, reference number LR number 1504/13, where the deceased was the third respondent, was the third defendant, regarding ownership of a piece of land situated within Lolongo Wade Bridge in Athi River Sub-County. A matter which was being investigated by DCI in Lolongo. Your Honor, the said land dispute brought about an eviction and demolition of the deceased family properties on the said piece of land. And that shortly after the eviction and demolition of the deceased family properties, the deceased started to receive death threats where she'd be constantly trailed by unknown men riding on motorbikes while she was driving. And on the 7th of July 2026, while she was driving along Gong Road near Junction Mall, two unknown men riding on a motorbike pointed a gun at her and tried to shoot her. However, she was able to flee the scene and later filed a threatening report at the Kilimani police station via OB number 63/07/07 of 2026. And after this incident, the deceased reported to the police and her husband that the pillion passenger was among those who had trailed her and identified him as a second respondent. That the pillion passenger was among those who had trailed her and identified him as a second respondent. And on the 27th of July 2026, while she was driving from her homestead to her office, she was again trailed by unknown men in a motorbike and again reported to the police. And investigations are underway. The first respondent is an ex-wife to the deceased husband. Whether the first respondent divorced with her ex-husband in 2001. And that before the divorce, the first respondent and her ex-husband are blessed with 4 children, among them the second respondent. In Karen, leading to the arrest of the respondents on the 30th of July 2026, pending arraignment. During the arrest, the second respondent during the arrest, the second respondent was found in possession of crucial exhibits relating and belonging to the deceased person, which the investigation team strongly believes that the said materials are shared by the second respondent with the unknown gunman before she was brutally murdered and pending forensic analysis. One of the applicant's investigators have established that the respondents are well known to the chief prosecution witnesses, who include members of the deceased family and other people connected to the long-standing land dispute that forms part of the investigations. The respondents are aware of the identities of these witnesses and the nature of the evidence that they are likely to give. If they are released at this stage, there exists a real and substantial likelihood of witness interference, intimidation, or compromise, thus prejudicing the ongoing investigations. Your Honor, investigators have established that the persons who executed the fatal shooting, including the gunman and the motorcycle rider who facilitated the commission of the offense, remain at large. One of the applicants investigators have reasonable grounds see that the respondents possess information regarding the whereabouts and identities of the suspects. And that if released, at this time they are likely to communicate with them. Facilitate their escape from justice. Assist in concealing their whereabouts. Or enable them to destroy or conceal evidence. One of the principal witnesses is the husband of the deceased, who is also a crucial identifying witness. And owing to the traumatic circumstances, he is yet to record a statement, a comprehensive statement. His vulnerable emotional state necessitates protection from any actual or perceived intimidation. And the release of the respondents before his statement is fully recorded may compromise the quality and completeness of his evidence. Your Honor, several critical forensic examinations remain incomplete. Including ballistic analysis of the recovered exhibits, forensic examination of CCTV footage, analysis of call data records, forensic examination of exhibits recovered from the second respondent, and the postmortem examination of the deceased. Your Honor, the release of the respondents at this stage poses a significant risk of collusion with other suspects who remain at large. And continued detention is necessary to preserve the integrity of the investigations. Your Honor, the matter has generated widespread public interest and significant public outrage due to the circumstances under which it occurred and the profile of the deceased. The identities of the respondents have become known to members of the public, and to the deceased family. With a genuine apprehension that if released before investigations are concluded, their personal safety would be at risk. Your Honor, the same is supported by the affidavit of the investigation officer, Corporal Romano Odor, and the Homicide Investigations Bureau.
Your Honor, I'll take a brief time to just point out this court to the relevant law and authorities that we are basing our application on. And I will begin with the supreme law of the land, which is the Constitution, Your Honor, under Article 49, 1, F and G, which was given live by Section 36A of the CPC, in which, Your Honor, under Section 1 and 2 of Section 36A, requires that when a police officer arrests a suspect, to present the said suspect before a court of law within 24 hours. And if there is a need of putting that suspect for more than the said 24 hours or in continuous detention, to present an application of that nature before a court of law. Before you, Your Honor, the first requirement under Section 36(1) and 2, that 6A(1) and 2, have been met by the application before you today. And what this court is required to look at is whether the said application, Your Honor, meets the threshold of the requirement provided for under Section 36A(3). And I invite this court to have a look at Section 36A(3), which provides 4 limbs in which the said application will be considered to have met the set threshold. And to start with, Your Honor, is that the said application need to be supported by an affidavit, and as presented by my colleague, there exists an affidavit in the said application of an officer by the name Romano. And therefore, this application, having that affidavit, is rightly before you. And 36A(3)(A) calls for this court to look on whether in that particular application, whether the nature of the offense with which the suspect are to be detained is mentioned or is well articulated. And Your Honor, in the affidavit or in the application before you, under paragraph 2, and throughout the affidavit, the nature of the offense is well mentioned, to it being murder under section 203, so together is section 204 of the Penal Code, which is an offense well known by the laws of Kenya, and therefore the application before you meets the first limb of the 4 limbs. The second limb is the general nature of the evidence. Your Honor, the said application contains very elaborate grounds outlining some of the evidence, the general evidence, including the cartridges, the bullet head recovered from the scene, the CCTV footage, the deceased and respondent call data, the documented land dispute, a documented pattern of threats and pursuit of the deceased, which includes the attempt shooting on 7th of July and the further pursuit on 27th of July, of which both have been reported under the OB number well outlined in the application, and they were active investigations. Further to it is that the deceased identified the second respondent as the person who was among the pursuant on 7th of July. Furthermore, Your Honor, among the general evidence is the exhibits belonging to the deceased that were recovered from the second respondent, upon arrest. You know, with that, the second limb of this application has been met. The general evidence is well outlined as required by Part B of Section 36A3. We go to the third limb. Inquiries made and proposed to you. It has been outlined to you that the CCTV footage, call data records, and other information recovered from the second respondent have been forwarded for processing and forensic analysis, including the cartridges and the bullet head that were recovered at the scene. Including the vehicle that was carrying the deceased at the time of the shooting is still undergoing further investigation and forensic analysis. And therefore, the third limb is as well met, Your Honor. The fourth limb that is provided for under Section 36A 3D is one of the most important limbs, which to it is reasons necessitating continuous detention of the suspects. Your Honor, the application has pointed out reasons necessitating the said continuous detention, to it being interference of witnesses, simply because the said witnesses are well known to the respondent and the family of the deceased. You know, and in consideration that there existed a civil case, and the application also informs this court that the husband to the deceased had also been informed by the deceased of the pursuit that had occurred on the 7th of July and the attempted shooting. And the husband to the deceased being an ex-husband to the first applicant, to the first respondent. This is a clear connection and indication that some of the witnesses are well known. And the term well known, I think it's an understatement, Your Honor. They are well known, and therefore there is a very high likelihood of interference with the witnesses. Your Honor, the other reason why we are requesting for continued detention is the significant public and community outcry generated by the killing. Your Honor, I don't need to say much on that because it's well known and it has been well articulated in the application and the subsequent affidavit accompanying the application. Your Honor, the other thing is the safety of the suspects. The murder, Your Honor, being a high-profile murder, has resulted to outrage the members of the community. And since, Your Honor, the law provides for fairness on both sides, it's only fair if the said suspects are put into detention for their own safety. And furthermore, Your Honor, under the same application, there is also a ground that the said respondent needs to go a mental assessment to see whether they are fit to stand at trial. It's very clear, Your Honor, that the said application before you has met those volumes, and therefore well placed before you, and you have the jurisdiction to adjudicate on it. Section 36A, 4, empowers you to do, among other things, under section 36A, 4C. Having met the requirements under subsection 5 to put the suspects in custody. Your Honor, section 36A7 gives you discretion to put them in custody for a period not exceeding 30 days. And which is the period we are seeking here? And Your Honor, section 36A5 direct this court that it cannot put the said respondent in custody unless we as the prosecution have given compelling reasons to make the court believe that the suspect should be put in custody. And Your Honor, the said application has really outlined in details compellable reasons. And these compellable reasons include among others, interference with witnesses, safety of the suspects, public outcry, among others, Your Honor. And these compelling reasons, Your Honor, have been discussed in several case laws and authorities. And I wish to point this court to have a look at the reasoning of the learned judge, Justice Kabeza J. in a Republic versus William Imoli Shogali, Shigali, Your Honor, Shighali, alias Imo, and two others. Criminal case number E006 of 2025. Where compelling reasons were discussed. And also, I will be inviting this court to have a look at the miscellaneous application number 007 of 2023. There's a criminal miscellaneous application number E007 of 2023. Republic via DCI versus Denge Mackenzie and 17 others. Well, among other things that were discussed, Your Honor, was the public outcry in the said two cases. The seriousness of the offense, and on the seriousness of the offense, Your Honor, the parameter was set in Republic versus Pascal Ochieng Lawrence, 2014 EKLR. And among grounds that were discussed under this claim included, among others, safety of the accused, likelihood of attendance when called upon, jeopardizing community security, among other grounds, Your Honor. And also invite this court to look at the Malawi case, a decision made by the Supreme Court of Malawi. In John Zenus, Zenus, Ungape, that is UNGAPAKE, Tembo, and two others, versus Director of Public Prosecution, M.S.C.A.CR. Appeal number 16 of 1985. Where in this case, the Supreme Court observed that the gravity of an offense can make a suspect abscond, making the said suspects of flightless. You know, under the risk of interferences with the witnesses, I want this court to have a look at the threshold set in Republic versus Dwight, that is DWI, GHT, Sagare, that is SAGA, RAY, and four others. 2013 KEHC, KLR, where it outlined and discussed the issue of interfering with witnesses in details. And which was further anchored on Republic versus Jackton, that is JOKTAN, Joktan, Mayende, that is MAYENDE, and three others, 2012 KHC, and in which this particular case, and very relevant to the application before you, it noted that interference can occur at any stage, including at the stage of investigation. Having demonstrated this court that the witnesses in this case are well known to the respondent and the deceased family, then the likelihood of interfering with the witnesses is not just a mere suspicion, but is a fear that is there. You know, on the issue of public interest, public safety, and the safety of the respondents, I will invite this court to have a look at the case of South Africa, the Constitutional Court of South Africa, in S versus Dlamini, that is DLA-MINI in brackets CCT 21/98 which it discussed the issue of offenses that triggers public outrage, which is similar to the suspected offense before you. And also the Supreme Court decision in Republic versus Ahmed, Abul Fadi, that is ABOL FATHI Mohammed and another 2018 EKLR, where the Supreme Court indicated that perceived threats to public safety can cause continual denial of release before proving trial, and further to strengthen that particular point, Your Honor, I invite this court to also have a look at Republic versus Bernard Karisa Maida and another 2014 EKR, and also Republic versus Karaoke Mwaneki 2016 EKLR. Those particular authorities, Your Honor, engages section 36A 5B directive, and which is among the grounds that you have sought for the 30 days before you. As I finalize, Your Honor, I have indicated to this court that the law, Your Honor, gives you power. It gives you power to grant a detention in the first instance of not more than 30 days. But the drafters of this, part of very important law of this land, knew very well that the 30 days might not be sufficient. And under subsection 10, it goes ahead to say that if the investigations are not yet over, the said officer might come back to you and seek for extension. And the only caveat put there is that as long as altogether, cumulatively, the days does not go above 90 days. We are not even asking for the said 90 days, Your Honor. We are asking for 30 days. Your Honor, these investigations include a multi-agency approach. The issue of multi-agency approach was well discussed in the Mackenzie case that I outlined up there, Your Honor. Miscellaneous application E077 of 2023. And in this particular case, there are several agencies that are involved and who cannot be able to work on some of the evidences at the same time because they require full engagement and concentration. And in order to preserve proper chain of custody and to give the said agencies sufficient and ample time, of which the court will agree with me that the 30 days are not even ample time, but the applicant is ready to work with the 30 days, so that they can divide the 30 days amongst themselves, the agencies, to complete the investigations, in order to serve justice to both the victims and the suspect. Your Honor, the court is supposed to be a neutral arbiter, and it only works on facts as presented. And for it to reach into a finding that is just to both sides, it must be presented with relevant facts, which can only be secured through investigations. I also request this court to look at Section 10 of the Victims Act, which speaks to the issue of protection of witnesses, to safeguard them from being bribed, threatened, and all other manner of things that might amount to interfering with witnesses. With that said and done, Your Honor, is my humble application that you find merit in this application and grant the applicant who said 30 days to conclusively work on the investigation and present the findings after the investigation. The applicant, Your Honor, is ready and willing to comply with the direction that after the said 30 days to appear before you with a status update. They are willing to comply with that. With that said, I pray that you can merit in our application and grant the applicant the said 30 days. And I rest, Your Honor.
Yes, Your Honor, on behalf of the family, we wish to adopt the submissions by the non-prosecutor and reiterate that there are compelling reasons to detain the suspects for a period of 30 days. One of the factors that you need to consider in granting that application are one, the gravity and the nature of the offense. Murder is a very serious offense under the Kenyan laws. And the suspect facing such a capital charge has overwhelming personal interest in evading justice, and therefore detention during investigation is proportionate to the risk. Number two, there is ongoing investigations, that is forensic and scientific investigations. And Your Honor, these investigations, as already submitted, are inherently complex and time sensitive. The investigating team thus requires ample time to complete the critical aspect of the investigation. Whether there is equally the risk of interference with the witnesses and evidence. Your Honor has already submitted the user history and the witnesses involved are known to the suspect. This being a murder case, Your Honor, there is a likelihood that the witnesses will be intimidated. And there's a possibility that they will fear to come forward and give critical evidence. When based on that, we support the application and say that the respondent be detained for 30 days to enable the prosecution file a report. And when the 30 days lasted. And that would be all.
John, please. No, start, then my colleagues can be able to follow up.